Get started.
Okay.
Awesome. Well, thanks very much to everyone and welcome to the Globinar on what's up in global law. And we're hyper focused on domestic and global intellectual property today. So thank you for joining us. And because this is America's 250th anniversary, we've adopted a red, white, and blue America's 250 theme. And along those lines, because intellectual property is in the Constitution, and as you can see on our cover slide, it promotes science and the useful arts, provides a limited monopoly to authors and inventors, and it's accessible to everyone in America. So one of the best promoters of innovation and intellectual property is the Constitution, and we have four practitioners to build on that theme today, and I'm excited about having them join us. Uh, as you might be aware, in Article 1, Section 8, Clause 8, it in fact has that language in the United States Constitution, and it's been a hallmark of our country. Uh, Part of it may be exemplified by Garrett Morgan, someone who was born in 1877 in Paris, Kentucky, sixth grade education, formerly enslaved, and who proceeded to not only invent in the sewing space, but also to invent a protective hood for firefighters, which ultimately became the gas mask that United States Armed Forces used in World War I and other places. Uh, Someone you wouldn't expect because innovation can come from anywhere. And on that point, we have four folks to help you identify and have a discussion about what are these innovations and give you some ideas about potential sources and actions to make them valuable. Yeah. Marcos Giacosta from Marcos Law from Arizona, Nicole Gaither from Cloth and Code in the District Metropolitan Virginia area, Joey Mithapara from Dickinson Wright, also in the District Metropolitan Virginia area. And we're going to have a fun discussion. We encourage you to put any questions or comments in the chat. And as we power through this, we will look to try to have an opportunity for interactive Q&A. Quick caveats: not giving legal advice, sharing best practices, observations, and experiences. Please be respectful, but do put your comments and questions in the chat because we want to be able to make sure you get value from the experience. This is a quick run of show of what we're going to work to cover today, especially on whether or not you have IP already. What are those forms of IP? And then are there some emerging forms of intellectual property that might be helpful for you to understand? So let me hand over to my colleague, Myla Catalan. Myla, any opening remarks that you'd like to mention on behalf of our sponsor, the Global Chamber?
Oh, I'm sorry. I'm just here to moderate. It's usually Doug who does that. So I'm sorry. I wasn't prepared for this.
So,
But
Chris, if
yeah, it's glad to be with you. Thank you for presenting for Global Chamber, and thank you, Chris, for your leadership for this webinar.
Well, thank you, Myla. Thank you for hosting and putting together the infrastructure to do this. So let's have a brief introduction from our panelists today. We'll start with Marcos, then ask Nicole and Jomi to briefly introduce themselves.
Hi, good morning from Arizona, beautiful Arizona. This is Marco Garcia Costa. I work and I'm the partner and founder of marcoslaw.com, and we provide services, global services on business and intellectual property. And one of our focus is the global Latino, Spanish-speaking people around the world that wants to do business with the United States. I'm a member of Global Chamber as well as Chris, and it's one of our main sponsor and infrastructure that allows this to happen. And it has chapters all over the world, and it allows for connections between people so we can do business in a global scale.
Thank you, Marcos. Nicole, if you would.
Sure. Thank you, Chris. I'm Nicole Gaither. I'm a trademark and copyright attorney. I'm the founder of Cloth and Code Legal, based in the District of Columbia. I am also licensed in Louisiana, so I am currently sitting right outside of DC in Virginia. I also hold another hat. I am the supervising attorney and an adjunct professor at Howard Law. I teach the IP Trademark Clinic. So I have been doing trademark and copyright law now for a little over 8 years and don't see myself going anywhere else with it. So I'm glad to be here.
Thank you, Nicole. Jomi, how about you, please?
Sure. Thanks, Chris. Good afternoon, everyone. My name is Jomi Mathapara, out in Washington, D.C. area. I've been practicing law for about 15 plus years. I am a business tech lawyer, focusing on intellectual property, mostly on the patent and trademark side, mostly on the transaction side, but I also support some IP litigation from time to time. Do a lot of public company work, but then I also get involved in the small mid markets, including FDI work. Um, and there I get involved in a host of issues, including IP. I'm a partner at Dickinson Wright, which is a full service national law firm, Midwest based in Michigan. And so, yeah, we provide comprehensive legal services and at mid-market rates. So happy to be here. Thanks, Chris.
Thank you, Jomi. And I'm Chris Bennett. I'm the founder of Technology Innovation and Law, TIL for short, which is a social impact IP legal services provider based in Washington, D.C. And we have a separate complementary legal tech venture called IP Rights for All, which uses artificial intelligence and intellectual property to make creating and protecting intellectual property rights more affordable, especially for historically underserved communities. And got to give a shout out to our audience. I see some welcoming in from Stephen at Ames International in Germany. So welcome, Stephen.
Right.
Also,
So, yeah, Steven Sturman, I'm a partner with Ames International in Germany. We're worldwide one of the largest executive search firms and talent management, talent development companies. I've been in the Global Chamber now for roughly around 3 weeks with our company, and we're expanding. One of the main points where we do is we try to help small to mid-size companies that are growing locally as well as internationally. My background is I'm an American. I've been in Germany now for more than 30 years. Um, so one of the things coming from this side going into the US, we're now seeing a number of small to mid-size German companies, innovative companies that are now looking to expand, grow into the market. And, one of the issues, especially with the US, is is the legal situation, which is very different than in a number of cases than in Germany and in Europe. And wanted to go to attend this meeting just to get a feel what's going on. You never know if the question comes up. We are not a law firm, and it's always good to say, well, we don't do this, but we know somebody who might be able to help you out. And it's one of the reasons why I decided to attend today.
Stephen, thank you so
So,
much for that.
should mention actually, which might be interesting, we cover over 70 countries. As I mentioned, we're one of the largest ones worldwide.
Stephen, thank you so much for that. We're going to power forward, and then I see some others that I want to acknowledge, like Renee, but we'll thank you. We're going to move forward in the agenda. We appreciate that share in some context. All right. So with that share, let's see. One moment. I'm going to refresh my screen.
So best luck on the next round, Stephen. No work up.
Okay. And as you might recollect from What's Up in Global Law, one of our standards is we use AI to kind of get the conversation started. And so we use the same prompt for 5 different large language models, Claude, ChatGPT, Gemini, Perplexity, and Llama. And the question we asked was, or the prompt was, what is the most important development in domestic and global IP law today? I'm going to read off very quickly, but and ask our panel, do you agree with these issues that are found, or do you think there's another issue that's most important? You know, Claude says, oh, it's who owns AI that's created by intellectual property? Excuse me, who owns AI created intellectual property? ChatGPT said it's the US trademark that protects nothing abroad and that AI counterfeiting outpaces enforcement. Gemini decided wants to, excuse me, Gemini talks about the European EPO, China, and the USPTO, and the fact that their approaches to inventorship are different, so not harmonious. If you're global, that's a challenge. Llama talks about the Defense of Trade Secret Act and that it wasn't built for AI scale misappropriation and for proprietary training data. And last but not least, Perplexity says, hey, US, EU, UK, Japan, four incompatible rules on fair use in related areas. So, panel, let's start with Nicole. Do you agree with something that the LLM said, or do you have a different view?
Well, I'm going to focus more on the trademark and copyright side of it. I think there definitely is a question regarding who does own AI created IP because first of all, most of us are familiar with AI that's generated, like you put in a prompt, but it's coming from a data set that is probably, expansive, pulling from the internet. So it's generally pulling things that might be owned by others. So the question is, can you own items that are owned by others? And then what is the output? Is that something which in my understanding and belief, you can't really own if you didn't put that much into it? Like you didn't really control what the output was going to be. Something else spit it out. As far as like the training data ownership question, I am one of these people who truly believes the courts are getting it wrong here, but maybe there is some justification, but I just do not believe that this is fair use. Like you cannot tell me that putting someone's book in AI is the same as somebody reading it. Like, yes, I once I read a book, I probably will have an understanding and knowledge of it, and I remember what happened, but I'm not going to go spit out and create a book based on that style. Like that would be close to infringement. So yeah, there are some views here. Like I think every single day we're starting to see more, and I'm getting a little afraid of the fact that, we have AI that it's taking stuff from creatives like videos and photos and like basically recreating things that are nowhere near what they originally were. So, deep fakes, all of that. And I will stop because I'm sure other people have thoughts on this.
Thank you for that share, Nicole. Jeremy, what's your view on what the AIs or the LLMs said? Do you agree with some or one of those? Or you have a different perspective?
Yeah. I can talk about the Gemini AI evaluation. US PTO, EPO, and China diverge in AI inventorship. Certainly, that's true. I think we're kind of in an AI race right now, particularly between the US and China, but also Europe and other countries in the world. And so regulation is going to slowly follow, right? In an AI race, you don't want regulation to lead because that will stifle innovation. And all these countries are really, competing against each other to get ahead on AI, for good and for worse. And so hopefully, at some point, regulation will catch up in a meaningful way and provide guardrails, and then there'll be some sort of worldwide um, uniformity or consistency in the law. But it's a process, right? And so because AI is in its nascent stages, naturally these are some of the challenges that we are experiencing.
Thank you for that, Jeremy. Marcos, what's your view? Did the AIs get any of it right, or do you have a different perspective on what's most important today?
Well, who am I to disagree with the electronic overlord? Okay. No, I don't want them to come back at me and start targeting me. So no, unfortunately, we all agree with them. Uh, there is definitely differences in the approach around the world. It is interesting that China has a more hands-on approach, but also is very specific, like, for example, censorship. If you ask AI in China about what happened in Tiananmen in 1989, June, I think June 4th, it's gonna say, oh, it was a beautiful day. It's not gonna tell you the truth. But other than that, from a technological perspective, from the hardware side, they have been investing a lot. So specifically on AI generated, I like to think that the United States has been setting some standards. We'll see how the rest of the world follows, where they want it to be a human centered, especially for patents. Has to be human centered. There has to be a substantial contribution, and I think if you just go through again specifically for patents, what is a who gets credit for a patent? Anybody that contributes substantially gets credit, but the keyword is a person. So if it is all done by AI, it's probably not a person, then therefore it's not doesn't qualify for protection. So the other thing is, if it is totally generated by AI, there's the high risk that it is novel, which is one of the requirements, and may be anticipated. So you get into the nitty-gritty of the rules for patents, but that's one of the things. The other thing I tell people is be careful what you put on a public chat, because then it becomes prior art. That especially for our audience from other countries, you may get a protection in the United States, but if it is not filed in other places, then it can be fair game and anybody. I find it very difficult that it will just pop up and say, hey, yes, but invented this thing. But there's the possibility that, somebody that is devoted and knows what he's looking for could find it somewhere else in the world.
Marcos, thank you for that reply. Thank you for that information. So now we're going to build on that AI-driven prompt discussion and just quickly reconfirm that there is generally 4 traditional forms of intellectual property: copyrights, creative expression, trademarks, service marks for branding, trade secrets, and then for patents. I will share emblematic of this intellectual property regimen. The United States has a registered trademark on America 250. So it is pervasive. And if you're writing anything, you're into the copyright space. If you're doing business, you're into the logo space for branding. Trade secrets, you're taking reasonable measures to keep something that's a secret, which is perceived to have value in the marketplace. And patents, these are inventions. And each of our panelists is going to hyper-focus on those as we go. But let's start with what I believe is one of the most accessible forms of creative expression is copyrights. And everything that you just heard our panel mention is relevant to this. We have clients we're working with that have filed for software copyright protection, and the Copyright Office in the United States is being rigorous in identifying where was artificial intelligence used, how was it used, did it actually generate the source code? And what we're finding is that some of those disclosures can result in exclusions. For example, we have a client that used artificial intelligence powered tools in their design, but they wrote the source code. And so now the Copyright Office is asking us to disclose that and have exclusion for it. So the ownership of AI-generated intellectual property is real. But it's not just that. It's also the tools that are now AI powered may create potential risk. And it underscores the importance of having wise counsel to know the right questions to ask to help customers and clients know what they don't know as they go through the process. Anyone else on the team want to drop in on copyrights before we move forward in the agenda and dig a little bit deeper?
Especially for our international audience, copyrights can have a broad coverage where you could enforce them or try to enforce them on other jurisdictions. So always get us an assessment and support from local counsel. And one of the things I'm an engineer by training, so I tend to be nitty-gritty about the details. When you file for a copyright registration here in the United States, it will ask you if there's any I don't remember the wording, but basically you're using some copyrighted material from somebody else, or so basically you're only protecting the new creation. So I think that could be also, transfer to AI assistance, because in theory you are using AI, it's pulling from a lot of existing sources and may or may not be a complete new creation, which is, the base for a copyright.
Thank you for that, Marcos. And I see Stephen has his hand raised, and I'll mention one thing before we go to Stephen. One of the most powerful aspects of copyright is that there is an unregistered component called common law available in the United States, in addition to the registration. And we're seeing that as a tool that we're working to empower creators and entrepreneurs to become aware of and to use that as they pursue intellectual property with copyrights. Stephen, would you like to briefly drop in and add something?
Yeah, I think my understanding is, I mean, from what I've seen, and I've been living here for a long time, at least the understanding for copyright laws and the understanding in general between Europe and the US are pretty similar. I mean, the from the values, etc., you don't steal somebody's property, etc., etc. But how, when you're protecting, if your clients are US companies, Europe, I don't think would be a major issue. But how do you pursue anything outside of, let's say, Europe or the US if your copyrights have been infringed?
Excellent point, and we could have a separate discussion on that. I will simply say that the Berne Treaty is one mechanism that we look to leverage for clients with whom we work, but also it's having an ecosystem of organizations, especially in different jurisdictions. And we've experienced this in Africa that can be helpful in finding the right remedies. So I'm going to push on in the interest of time, but definitely we can set that as a follow-up question. We can ask our panel to share their thoughts with you after this event. So thank you for that. And now let's go to trademarks and let's ask our colleague Nicole to kind of lead her thoughts on trademarks and how do you protect it domestically and internationally.
Sure. So, kind of going back to the basics of making sure that we all understand what a trademark is. Think of these as the things that help people identify the sources of your goods and services. They're like your brand name, your logos, slogans, taglines, anything that helps identify your goods and services in the marketplace. We can even protect smells, sounds, things like that. Rights in the US come from use. So we are a jurisdiction where you get trademark rights once you've started using a mark in connection with the sale of goods and services. Registration is not required. However, it is a definite benefit, especially through federal registration, because you gain nationwide ownership to your trademark. You have the rights to exclude others from using certain things that, the USPTO will actually even, I call it, help you a little bit in trying to enforce your rights to make sure that someone is not going to try to register a mark or start using a mark that is similar to yours. As far as the international scale, the USPTO does have an opportunity for you to be able to file with other jurisdictions through what's called the Madrid Protocol, where at a certain period of time after you filed in the US, I think it's about 6 months after filing, you have the right to file through the Madrid Protocol with other jurisdictions that you might be looking to operate in or sell your goods in. So you can do that through the USPTO. Of course, there's some fees associated with that. Other options are if you decide you don't want to go that route, you can file on, your own through those other countries. The other thing I kind of want to mention, because I know in the interest of time, I kind of want to make sure that everybody can get through stuff and we can have time for questions. Registering, like if you are going to be selling in the United States, registering with the Customs and Border Protection, and I want to call it patrol, but it's protection, goes a long way. But you are required to have registered with the United States Patent and Trademark Office in order for you to get those rights. The Border Protection allows you to prevent things that might be counterfeits from coming across the border that, could really endanger your goods, your reputation, and also your ability to be able to import and export if there are other issues there. And I will allow other people to kind of chime in and fill in where I might have left some holes here.
Nicole, thank you for that. I think we can offer anyone on our panel that wants to drop in with a brief comment an opportunity to do so.
I'll just add to the comment from Nicole, good observation on CBP, the customs protection. It can also apply for anything that has a registration. So for copyright, for example, in the old days, we had CDs and cassette tapes and videotapes. They would do pretty much impound and stop products that were infringing, and they still do. I got a call from a client where they had bought some toys and cars and little things like that with logos of Mercedes and Ferrari and things like that. They didn't have authorization to use those brands, so they got impounded, and they just happened. So yeah, you can do that if and those big companies, the Coach and all those guys, they have big big operations and collaboration, especially in pharmaceuticals as well. You got patent copyrights and trademarks that they can be used to stop infringing products.
Marcos, thank you so much, Marcos. In fact, great that you mentioned that because we're on the trade secrets and we ask you to lead that. So could you briefly share your perspective on protecting that domestically and internationally?
Yeah, and there's three things that I mentioned. I don't know if that resonates with the audiences outside the United States as what is a trade secret, but it is the Coca-Cola formula, and I guess by extension the Pepsi-Cola as well. The Kentucky Fried Chicken secret sauce and the Google algorithm. Basically, I tell people if it is something that you think it's so valuable that you don't want anybody to know and you want to protect it, don't tell anybody, don't register. You need to have a layer of protocols in order to make sure that it stays a secret. And there's been cases where the Coca-Cola formula, for example, has been stolen, and the authorities intervene to stop that and prevent the dissemination. So there's got to be in your processes, internal processes, you gotta have protocols for classification, confidential, and depending on the type of company I've seen in technology, you got just confidential, where anybody inside the company can see that, and then secret, restricted secret, top secret, whatever. And you need to decide, and you need to have controls over who get to see that material. So most of the time, when people come in, especially in the software, and the software is probably one of the areas where it is going to be more most applied, because people think that a patent will protect them, but in reality, a patent, just like a trademark, it's something public. You need to tell people how you do things. So if it is so secret, it's so special, you don't want to do that. Specifically with Google, if you go back when Google started, they filed a patent for how they were going to do their algorithm. Then from there on, they never published, never did any patenting, because they realized that having control over how that algorithm internally works was very powerful. So you got all these people trying to figure out how that the new release of the Google algorithm works, and then there's a whole industry around it trying to, figure out what's inside the black box. So we have an idea because they had to disclose every sort of detail in a patent originally. From now on, we just have to figure out from the shadows and the noises from the box what's inside. So for software, where a patent may take 1 to 3 years to come through, for the most part, it's not worth going to, it may be better just to keep it secret. I usually tell people if it is something that can be easily reverse engineer, something physical, like a mechanical device or a chemical compound, then probably want to protect it with a patent. If it is something that people don't get to see, like that chemical compound, but you have a process for a special process for making it happen, you probably keep part of that as a secret, and then other parts can go out as a patent. And then obviously the cherry on the cake is the trademark. So that's what makes a difference between a leaf and naproxen, for example. I take it for my back pain, but naproxen is the generic and anybody can make it. But I leave it's just a trademark very specific to that. And I'm sure there are patents of how naproxen was the formula for that, but you probably will never know how they do the mixing, the machines, even how the machines work to make that happen.
Marcos, thank you for that. Does anyone else on the panel want to briefly drop in with an add on trade secrets? And I'll lead by saying what we're seeing in the space are a couple of things. One, a lot of software developers are looking to combine copyright with trade secret as one means to protect their software code. And most of the trade secret litigation we're seeing is related to employees. So that point on the lower right of departing employees, the number one source of trade secret theft, is bearing itself out based on the case law that I'm seeing. Marcos, thank you so much for that share. Let's next go to a topic that you mentioned, patents. So, Jomi, would you drop in and share with our audience your perspective on protecting patents from a domestic intellectual and international perspective?
Sure, Chris, thanks. In the US, there are four major categories for patent protection: process, machine, or like a widget, manufacture, and composition of matter. There are several areas in the Constitution that define non-statutory or non-eligible subject matter, which would be like abstract idea, which would include the algorithm, laws of nature, like gravity, and natural phenomenon. So maybe like, how a seed germinates and grows, right? Like Chris had mentioned moments ago, generally speaking, trade secrets are often more valuable uh, for misappropriation purposes if an employee leaves a company and is taking valuable information. Um, Whereas, on the other hand, patents are more valuable to work against competitors. So one litmus test to determine whether you should file for a patent or um, protect the innovation via trade secret is detectability, whether you can reverse engineer or not. If you can reverse engineer it, then patent protection is likely the solution for you. If you cannot reverse engineer it, like the Coca-Cola formula, then trade secret is probably the likely solution for you. Um, when we talk about patents, out of all the forms of IP, patents, copyrights, trademarks, trade secrets, patents are certainly the most expensive form of IP protection. That being said, it is also the most lucrative in terms of monetizing. Um, Patents does not give you a right to do business, but it allows you to restrict others from entering into the business that you're in. Um, Patents provide a limited monopoly for up to 20 years in the US. And the philosophical exchange between an inventor or a business and the government is that if you share your innovation, that will benefit and help advance science like technology. And in exchange, you will receive a monopoly for a limited period of time, right? And so there is a mutual benefit that that science and technology gain through the disclosure of technology, and then and in exchange there's a limited monopoly that a business or an inventor can rely on to recoup their R&D costs and uh, and exclude other people from entering into a certain market niche. As I mentioned, patents are the most expensive of the four forms of IP protection in the US. For a small business, uh, the cost for a utility patent, a single invention utility patent over the course of 20 years can range between $35,000 and $45,000. And if you file in multiple countries, surely that cost can multiply. And there are some jurisdictions that are a little bit more expensive than the US. For example, Europe and Japan, and others that tend to be a little bit less expensive, such as Mexico and Canada. Um, Again, these are generalities, and it really depends on the specific technology and what you're actually pursuing in your application. And of course, if you're able to obtain a patent or be able to build a patent portfolio, you have opportunities to monetize. You have leverage that you can use in the market to protect your product and to exclude other competitors from entering into it. In addition to that, it also patent protection allows you to enter into other monetization opportunities such as joint ventures, partnerships, licensing, royalties, and even in M&A. I tell clients all the time that IP can be up to 30% of the valuation of a company. That's, patents, copyrights, trademarks, trade secrets, and all companies have IP. But it'll vary from industry to industry and company to company. And last comment I'd make is that, patent litigation is when we talk about enforcing a patent litigation can also be very expensive. And for small businesses or even foreign businesses entering into a foreign jurisdiction, it is often um, avoided, right? But and here in the U.S., patent litigation can range from 2 to 4 million or more, and but the key is to have good patents, and if you have good patents, high quality patents, then there are litigation funding opportunities, and again, those open the doors to other opportunities to leverage your patents and to develop a monetization strategy.
Tony, thank you for that share. And I see Stephen has his hand raised so he can drop in and share his perspective as well.
Yeah, I just
Stephen.
had a question. When you mentioned with with U.S. Company applying for U.S. as well as multi-country. When you look at Europe, do you apply for a EU patent rather than Germany, France, Spain, etc.?
Yeah. You can file a patent application to the European Union and then
Mm,
validate in the specific countries that are members of the European Union. You can also file directly
mm,
in uh, in in countries that are part of the European Union and countries that are not. So it really depends on
mm.
where you're doing business and what countries you are targeting. And so good counsel can kind of guide you as to what's the better approach and what's the pros and cons.
How would the nasty question? How would the UK have been handled if they applied for a EU patent? UK drops out of the EU. Are those patents then valid for Britain as well?
Yeah, you could separately validate
No,
in UK.
no,
And
I meant for while the UK was a part of the EU. If somebody um, got a patent and that at the time included the UK, is that still valid for them or not?
yeah, yes, it is. And
Okay.
the way that the current model allows for that is you go through the European Union and you have the option to get a unitary patent, or you can validate into different countries whether they're part of the European Union or not.
Mm,
So yeah, so the change in the law is still keeps the prior patents valid, but also gives the applicant uh, different options moving forward.
mm,
Stephen and Jomi, thank you for that share and that discussion on patents. And we can actually carry that into the next segments with us if we want to continue it, uh, because we're at our final aspect of IP, and then we'll drop into Q&A. And that final aspect is what else? We know there are four traditional forms of intellectual property: copyrights for creative expression, trademarks and service marks for branding, trade secrets for perceived value that's kept secret, and then for patents for inventions. But there's some other forms that are being created as we speak. You see them on the screen: trade dress, web domains, AI generated IP, which is one of the biggest dollar sign controversies of big tech versus big creative. In the enforcement, non-fungible tokens, IP valuation. Jomi mentioned a percentage of potential value for IP. And in our research, we've seen IP value be measured on average as about 70% of stock market values if you're looking at it as an intangible asset, of which most of those are intellectual property. And the long-term trend appears to be that IP will become an even larger percentage of value from a stock market valuation perspective. So there are some other things to consider. Anyone want to drop in and add a perspective on what are the other forms of emerging IP that our domestic and international audience might want to consider?
So very quickly on domain names, something that we hadn't. I think we mentioned a little bit of everything, but domain names uh, they are controlled by a separate entity. But the one of the things if you want to do something on that area, it helps that you have solid registration, specifically on trademarks. Um, Nicole talked a lot about that. So you can leverage your registrations in order to protect or recover domain names if somebody steals it from you. The trade dress is a little bit can be a combination between the trademark, how things look, like McDonald's. But again, it is a registration that has to happen country by country, basically, whatever you want to, or region by region. European Union is one. And one comment I wanted to make on patents specifically is you have windows of time that you need to respect in order for you to be able to file and potential to get rights in other jurisdictions. So if there are a few rules of, if you haven't filed for a patent, keep it as a secret. And if you want to file for a patent, you have a window from the technically disclosure, public disclosure, and talk to an attorney for that. Rules may be different from country to country, but because they are trademarks, patents, uh, domain names, they are basically, part of international treaties. There are a lot of similarities.
Awesome. Thank you for that. Okay, now it's time to bring it home. We'll ask each of our panelists for their call to action to the audience, and then we'll go into Q&A. So, Marcos, you just finished, but if you were going to recommend one thing as a call to action to the audience, what would be that one thing?
Um, Usually, especially in trademarks, I tell people protecting, especially for small businesses, but even for medium, large businesses that are, trying different things, the protecting your name is probably the most important thing. A burger is a burger is a burger, but one is a McDonald's, another one is Five Guys, another one is the Whopper. Okay, and they may, for the most part, taste the same, do the same thing, but that's the big difference you're gonna get. So start with a simple or thorough, depending on your budget, IP potential analysis, and again, especially for the small businesses, make sure you have some budget for IP protection, whether it's going to be as simple as the name and the trademark, or a little bit more elaborate like copyrights or patents.
Hey, thank you for that, Marcos. Nicole, what's your call to action?
Um, I say do an IP audit. Like look at all of the intellectual property assets or things that you are using and doing, like your products and services. Look at the names that you're calling them. If you have any artwork and designs, like photographs, anything that is yours, are also looking at things that you might be using that are owned by other people, making sure you have proper licenses and authorization and permission to use those things. If you don't, figuring out if you need to go obtain those things or if you should stop using, like if it's a font or like software, anything like that. If those are things that you should probably get off your radar. But I feel just, doing a whole IP audit, making a list, so that you have that in case something goes wrong and you can say like, hey, we started using this name this date, or we started, we took these photographs, this, whatever. But I feel like that's probably the cheapest and freest thing you could do in your business starting today.
Awesome. Thank you for that, Nicole. Jomi, call to action to the audience.
Yeah, I would reiterate what Nicole said, and in terms of doing an IP audit and and investing in your business. Now, obviously, IP audit, assessing, what, going under the hood and assessing what is protectable and what isn't, and taking measures, taking steps to protect it. That does take time, that does take money, and you got to keep the main thing, right? Got to build the business, got to bring in revenue, but at the same time, you also want to slowly chip away and protect your assets to enhance your business and enhance the value of your business. And then my final comment is, in the new age of AI, as things, you know, uh, um, as innovation scales rapidly, the need for IP protection still remains, um, and the need to protect sooner than later is still relevant and important. Um, if we're waiting till the regulatory space to catch up or waiting for different innovation to develop, we might just be out of luck, right? And so, always better to file early and have a strategy to develop, to build out your IP assets.
Thank you for that, Jomi. And what I will say, I think, is complementary to what the panelists said. that is not only to do an IP audit, but we would suggest complementing that with first having an IP inventory. So actually having documentation on what the organization has with recognition of both the unregistered and the registered intellectual property rights. And that often shows up in due diligence on mergers and acquisitions. The other part of that, though, is to have a process for documenting the IP, because this is stuff that we're coming up with in our small businesses and large organizations coming up with every day. But because it's not documented and it's not captured in inventory, the opportunity may be missed or lost or diminished. And it especially applies to copyrights, which is a great segue to Renee's hand, which was raised. And I saw her question in the chat. So Renee, drop in, please, and share. Take a look and also read out.
There we go. Sorry about that.
No worries. Go for it.
My question is for Jami. He said earlier in his talk to have a good, high quality patent. And I'm kind of new to this whole game. So what exactly does that mean?
Yeah, no, great question. Oftentimes in the small and mid-sized business world, businesses kind of cut corners and maybe draft it in-house or use AI to draft an application. And and um and there may be situations where those patents grant, right? But ultimately, when you go into litigation, it may struggle with enforcement because of the right because the regulatory standards have not been complied with during um, uh, the drafting process and the preparation process. And so when I say, really have a high quality patent, really prepare your application well, right? And examine it properly, right? And so, businesses need to hire professionals and people that, it's like going to a physician, you can go to WebMD, but you may not get good care, right? Or you may get questionable care. And it's the same thing with lawyers, So having a trusted lawyer by your side, that understands the laws of a particular jurisdiction and preparing an application and then examining applications so that it is issued and and it can stand, in litigation and it can be enforceable, is really the fundamental difference between a good patent and a bad patent. Anyone can get bad patents, and if you have bad patents, well then you have no love. You have no you have no you have little strategies in terms of enforcing and monetizing.
Great. Thank you. Thank you so much for answering that.
Thank you for that. And I think we have 1 minute left. So does anyone have a question they want to put on the table for the panel? Then let me close it by saying there was a question about and this goes back to something Stephen mentioned, what can be done to protect copyrights domestically and internationally? That's a big issue. I'll just share what we've observed. It's a compilation of what you just heard from our panelists. First of all, it's understanding what you have that's copyright protected material and having that documented. That's like the first of 3 layers. The second is it depends on what may be misappropriated and who are the parties. What we found is there's some strength, for example, if you have a YouTube takedown that you need to do, or being able to submit evidence that you have a lawful copyright. In general, even though YouTube is a US-based corporation, we're seeing that in most cases they will honor that. So if there's a vendor involved that you can present that evidence to, that there's been a misappropriation, they may have a process that could help. If it goes beyond specific vendors and parties that you may be able to, with which you may be able to relate, that's where it's helpful to have an ecosystem, which could be an attorney, like a trusted attorney from this panel that knows someone in that jurisdiction, or it could be other organizations that know someone in a particular local jurisdictions, if it's international, that can take you through the right process to execute, to protect your IP. So that's what we've seen in that space. And before we close, I just want to ask, did anyone else have anything else they want to share before we adjourn for the weekend?
Just to say good luck to Germany on the next round.
Last night I stayed
Yeah.
up and watched that was sort of depressing, but okay.
Well, Germany is always Germany, so you cannot count them out.
That's a great segue. Good luck to everyone's World Cup teams in achieving success and going to the knockout round if that's what you like.
Okay.
Have a great weekend, everyone. Take
Thank
care.
you. Bye-bye.
Yeah, everybody. Bye.
Goodbye.